in two different firms and then my own firm. And then around 2000, 2001, somebody called me and said, look, we've got a case together. Not the person who called me, but another lawyer, and said, we would like for you to sit down with us and see if you could help us resolve it. I said, well, am I in the case? And they're like, no. And I said, well, why do you want me involved? And they said, well, we just both think that you understand the law and could be helpful. I was like, okay. So that happened once, and then it happened twice. And then the third time was kind of like, well, there might be an opportunity for other folks who could, have the assistance of an outside observer to help people bring resolution. Because look, at the end of the day, the end game for all of our cases is closure. And there are a number of ways that they can close. Somebody can pass away and that closes it. That's kind of a rare occasion. Somebody can wait long enough and the benefits run out. That's probably not a great strategy because of what it costs you. But probably the most effective is getting people around a table and simply listening to what their expectations are and then trying to educate them in a way that allows them to make a choice that's reasonable. And I never have to educate Patrick or anybody else in his group because that's the playing field in which they live. They understand the law, they understand the math, they understand SEBs, SMOs, IMEs, everything about the law they understand. But the real person that I spend most of my time visiting with is the injured worker. And probably 95% of them are represented a lot of times by people that we see often. And so you may be asking yourself, well, why would we want to mediate a case versus simply try and resolve it? And when I first started practicing, there was no such thing as mediation really at all. And there certainly wasn't in workers' comp. But what's happened from the mid 80s until around 2000 is that we became much more efficient in terms of communication, like cell phones and texting and email, and it allowed us to send out a lot more information, probably allowed us to handle a lot more files. But the real question that was always lagging is what's the effectiveness of that particular strategy? And so let's say that Patrick and I have a case, and let's say that I'm the plaintiff's counsel and he's the defense counsel, and he calls up one day and says, look, before we go down this path, my client would be interested in trying to resolve the case. Well, of course, as the plaintiff's counsel, that's always of interest to me because I'm not compensated unless there's a settlement. So like, okay, well, that's great. So Patrick said, why don't you make me an offer and then I'll visit with my client. So I put together an offer. I send it to Patrick. He visits with his client. He comes back. Let's say I make an open offer of $150,000. And just for the sake of our argument, everybody agrees the case is worth probably 85 or 90, but he gets 75 in authority. So Patrick said, well, we're not going to pay you 150, but and just for the sake of our little discussion, let's say that he's asked his client, where would you like me to start? And typically what I hear is, well, we want to be reasonable in terms of our offer, even though we feel like the plaintiff's offer is unreasonable. And what I'd suggest to you is that's the first loop or trap to avoid, because you cannot respond to an unreasonable offer with a reasonable offer. And so in Patrick's situation, he may say, well, we want to start at 30. Well, if we're trying to get to 75, that means he's burned about half of his authority and they're still at 150. So, but let's say that he does that. And then I asked the plaintiff's counsel, say, well, no, my client's not going to be interested in that. And he says, well, okay, well, maybe a counter offer. He says, well, we'll go to 140. Patrick visits with his client. He says, well, why don't you go to 45 or 35, something like that. Anyway, it goes back and forth like this. But here's the problem. The lawyers understand values in terms of how the law applies, but nobody has asked the ultimate decision maker, who is the injured worker, what is your tomorrow worth? And I ask that question in every mediation. And even the lawyers for the injured workers look at me sort of funny sometimes and say, what are you asking them? And again, all along with what's been progressing in terms of technology and efficiency and social media, along comes the lawyer advertising movement. Now, it's been legal since 1977 when Bates versus Arizona went up to the Supreme Court, but it took a while to take effect in terms of the amount of advertising we have. And I'm not an anti-advertiser, don't get that. But almost none of those billboards are talking about work-related cases. They're all talking about personal injury cases. So when somebody's injured and they see the name on a billboard of a lawyer and they say, X got me $200,000, well, that sounds good to me. And so they go to that person, they hire them or whatever. And they may have plenty of discussions with the lawyer that says, no, look, this is not a personal injury case. This is a work-related case. If I told you in 19 years of mediating and over 4,500 mediations, how many times I've walked into the room and that conversation has never happened between the lawyer and the injured worker. And so the injured worker says, well, you know, we started at 155. That's what I want. And the lawyer says, well, they're not going to pay you that, but this and all this. And so at some point in time, I'm usually asked, what's the value of this case? And again, I don't know if any, do they respond at all, or is it just kind of listen?
No, they can respond. It's chat's open if anyone has one.
If somebody asks you, let's say that you're negotiating, if somebody asks you, what's the value of my case? Let's say I'm the injured worker. What do you tell them?
I said they could respond. I'm not sure anyone will.
So we'll kick it back to Patrick. Patrick, what do you say the value of my case is?
Right now?
Any case.
Okay, let's see what Christine has. Not supposed to ask me questions. I don't want to say anything stupid. I am a little bit. I am a little bit medicated.
I took myself off mute. It's easier than typing. I typically, explain to them that there's a limit to how much, like that there's a gate on how much they can, how much TTD they're going to get. And, and I do explain to them about secondary earning benefits and, and VOC and how the reduction happens with, with if they're going to get a job and how much they're going to get for it. And how much they're going to earn going forward. That's I typically, explain it to them as best I can, to say, just to kind of bring them back down to earth so that they don't think that they're just going to get, those $200,000 settlements that they might be looking for.
Right. And so, and that was Christine, is that right?
Yes.
Yeah. So that's a really good explanation. But let me suggest to you that most people that I work with, and I'm speaking of the claimant or the injured worker, they have almost no familiarity with how long their benefits go on. There are more 3-letter abbreviations in Louisiana workers' comp than I think any other legal system. You have TTD, MMI, SEB, PTD, SMO, IME. It just goes on and on and on again. And that is the vocabulary that all of us are familiar with. And so what I say to people, if the lawyer says, well, what do you think the case is worth? I said, I know exactly what his case is worth. And they look at me with sort of a puzzled eye. And this is what I do. I say, Patrick's going to be our claimant. So I say, Patrick,
I felt like one.
There are 2 responsibilities that the employer or the insurer has in every workers' compensation case. And that's all that they're responsible for. And this is what it looks like. They have a responsibility to pay you something less than what you were making when you were injured. Now, I don't know who figured out that you can live on less when you're hurt, but that's how the system works. Secondly, and here's the real key, they never owe you faster than a week at a time. So if you're getting $400 a week, the value of your case, provided that you're here with us, is $400 next week. There is absolutely no responsibility for them to ever pay you faster than a week at a time. Your lawyer can't take this to court and say, look, Patrick wants his life back. He is tired of living on this system where he feels like he's treading water and he's going underwater. He's got a family. He wants this, and we want the judge or jury to ask him for that. I hear this from the Patricks all the time. We'll just take it to court. I'll say, stop. What is the court going to be able to give you? Well, I don't know, more than that. The court can only give you $400 a week, and by the way, they're paying you that right now. So there is nothing to go to court over. The other responsibility they have is for medical treatment, okay? Now, Patrick, you know the answer to this. When Dr. X finally gets something approved, where does that money go to Dr. X? It don't go to Patrick, it goes to doctors. So I said, you may well cost the employer, the insurer, more money over time. But the real question is, does that help Patrick get his tomorrow back? And the answer to that is always no. Because what we're trying to do is find out how much the other side is willing to pay. They cannot be forced to pay in advance on this timeline, plus something for medical that goes to doctors. And then we will end up at the end of this process with a number. And Patrick, I will look at you and say, does this amount of money in your hand in 30 days tax-free help Patrick Johnson move on with his life and his family better than $400 a week at a time in medical pay to doctors? That's the value of a workers' comp case. And so then they say, well, I can't get out of this without $200,000. And I said, I don't disagree with you. But I said, that's like taking a screwdriver and trying to drive a nail. This system does not award you for what you need to get your life back. It simply owes you $400 a week. Now, that's basic to all of us because we live that experience every day. Can I tell you, I have drawn this thousands of times. I think it's indelibly printed on my forehead when I wake up in the morning.
I have seen it left on a whiteboard marker and had to ask him what it all meant.
And the reason I do it is because there are certainly plenty of competent plaintiffs' lawyers out there. They are some of the poorest communicators in language that their client can understand. Look, I grew up framing, forming, pouring concrete. I worked in all those trades. And I understand a lot about where these people come from in terms of their work background. So when we start talking about values in cases and they've seen a billboard and they say, well, my case is worth this because I need to pay off my mortgage and I got a child going to college and I need to get back where I was before I was hurt. That's a great plan. It will not work in workers' comp unless we can settle the case. And that's why I start from the beginning talking about the value of your case is an amount of money that we can get the other side to pay, that they're not obligated to pay, that will give you more options than staying at $400 a week. And I usually follow up with that and say, I'm going to honor whatever you choose. I won't lean on you. I won't coerce you. But my responsibility to you and your lawyer and the other side too is to do my very best to say things in a way that are helpful for everybody to make a decision about the resolution of your case. And so when I never let them pick a number, Christine, when they say what it's worth, because they don't know how to pick a number. And I control this board. I walk out of that room sometimes and the plaintiff's lawyers erase all of my stuff and they start writing what we all see people do. Plaintiff, 200, defense, 5, 195, 7,500, like this. And I walk back in there all the time and those numbers are scattered all over my board. And I ask the plaintiff's lawyer, because I know him most, I say, what did you write on my board? Well, I was just keeping track of the numbers. And I was like, I'll get you a legal pad if you want to do that. This is my board. So when that happens, I erase all the numbers. I take the marker and the eraser and I walk out of the room. It's my board. And the reason that I do that is because visual and pictures are so much stronger communicators of messages. And I want to control what that discussion is in there. So if we write up there $200,000 as the opening offer, my first step is to get 200 off the table because Patrick, he's the defense lawyer now, has said, really, my client would like this case resolved at 75. I never ask Patrick, and he'll tell you this whether I'm here or not. I never say, what's your authority? I don't care. What I want to know is what will bring you into that place that your client feels comfortable paying in order to resolve the case, irrespective of whether I agree with the value or not. And he's exactly right. We've walked into many mediations And I've looked at enough of these and he has, and y'all have as well. I'm thinking, it's probably $85,000, $90,000. He goes, look, man, it's employer money and they've only given me 40 grand. Okay. That's what we got to work with. And we do our best to get there. Sometimes we do and sometimes we don't. But if I walk into that room and there's 200 written on there and I'm trying to get to 40, 200 sticks in that person's mind. I got to get 200 off the board. So again, Christine, thanks for inputting and saying that and all. But my suggestion to you would be spend your time, if in fact you're going to try and resolve a case by phone, very difficult by email, with an unrepresented person, explaining to them the value of a workers' comp case is what they owe next week. That's the only defined value. Does that make sense?
Yes, thank you.
Yeah, because, and we see this all the time. Because you go to a billboard, it's, this attorney got me 4,000, 400,000, 800,000, and that person looks perfectly normal. In tiny little letters, it says, not actual representation, because that person would be in a wheelchair. But it really is kind of an odd situation, because I followed him in mediations and we may go back and forth 2 or 3 visits with or I'm not the defense attorney, I'm just following him so I can learn how to mediate. And there's no discussion of numbers. I mean, I've had 3, we've gone into caucus with the other side and numbers have never come up. It's the employees' fears, concerns, they don't know the law. Their attorneys never explain to them, almost never, what the law is. They're just going to say, here's what I think your case is worth. We're going to go to mediation. And that person doesn't know. And sometimes, and I saw this one with Remy, where Remy Jordell, plaintiff's attorney, the first time, and the claimant said this, the first time anyone ever listened to my problems was when he told Alan, which, knowing Remy had already probably heard it too. That's just Remy. But basically for like 10 minutes, he was just talking about how much it affected him. He wanted someone to hear. He wanted someone to listen. And at that point, I realized, I'm like, money's not the issue here. I mean, because I had it worked out. I'm going to go in and Alan's going to start at this number. And then if I was a defense attorney, I would come in at this number and we'd go back and forth. And the first conversation, first 15 minutes, numbers were never mentioned. Never mentioned.
Numbers are really the last thing we talk about.
Yeah.
Because until we can get the message that a number is representative of a chance for Patrick to be back in control of his life, there's no use talking about amount.
Yeah, it's at the end of the day, and I tell this to plaintiff's attorneys all the time, especially young ones, because the young attorneys, they want to flex. No one wants to be talked down to by an older attorney who's been doing this forever, which I feel like I have. So I understand them. But it's like, well, Patrick, my client this, my client that. And I'll tell them, look, man, the person who controls your comp claim is me and my adjuster. I don't care what your doctor says. Frankly, I don't. I'll just tell my adjuster to turn off benefits. And if my adjuster's so inclined to put P&A on risk, they'll just turn off benefits. Most cases don't go to trial anyway, so it's not real risk. What do you want to do? What are we trying to do here? Are you trying to make my adjuster break down in tears or have them write a 6-figure check? So don't let them try and bully you. Because at the end of the day, you have all the power. Like he said, what I owe you is that check next week. And that's it. So where do you want to go from here? And that's one thing that I think gets lost in a lot of the negotiations, is because we come with numbers. It's all about numbers. And
so let's use Christine's example. So when she says that, I may ask them, what they think a value is and all, and they come back with a number that's 200,000 and you know that you're not going to pay more than $50,000-$60,000 on the case. Well, you have a real decision to make at that point, because if you make an offer by email or by phone to somebody who believes the value's at 200 and you're trying to get to 50, if that was in mediation and Patrick said, where do you think we ought to start? I'd tell him you need to start at 2,500, depending upon who the lawyer is on the other side. And I've heard over and over again, well, they're going to leave, man. They're going to be offended by that. I said, they are not leaving. They are here to get as much money as they can out of this case. I've never had somebody stand up and leave on the first offer. Never. Okay. Now, have they said, well, that's completely ridiculous and unreasonable? They say that all the time. And my response is, hallelujah, we got the first point that we can all agree on. They said the same thing about your offer. So 2,500 and 200,000, we now know the answer to what both sides are not going to accept. What we want to spend our time on is finding the number that they will accept. So my suggestion is, Mr. Plaintiff, go ahead and make a response, and then I'll visit with Patrick. And what we'll do is we'll see if we can get a playing field. We'll see if we can get in the stadium of where Patrick's client is willing to pay in advance versus pay slowly over time. And so he goes down to 195 or whatever. And then I go back in there and Patrick and I talk and I said, look, this is what I would do. And I'll come to this in a second. But my point is, email and phone with an unrepresented claimant who's completely unknowledgeable. They think they know, but they're completely unknowledgeable how the system works. You are spending money that you will never get any value for. And so Patrick and I have had this conversation. We may get close on the case and he goes, look, I don't believe I'm going to be able to get to where they want. I said, you shouldn't spend any more money today. You ought to let this case sit and simmer. And I said, let me walk back in there and say, I'm afraid we're not going to be able to resolve your case today. You'll get a check next week for 400 and you'll get slow medical once it's approved. But look, thanks for coming. And that will do one of two things. It will either shock them into, whoa, wait a second. I didn't drive 2.5 hours to come sit here for 3 hours to walk away with what I had when I came in. I need to visit with my lawyer a second and see if we can get this case resolved. Or they may get up and leave. And then I bet you next week I get a phone call and says, look, I talked to my client. I mean, sorry, the mediation didn't work out, but we really need to settle this case. Good. Then let's get back into the arena or the range that we can try to settle the case. And most of the time the case is resolved. People say, how many cases do you resolve? I don't keep track of that like every case, but I can tell you this, it's upwards of 90%. And it's even higher if we come to my facility because Patrick's been there. It's what I call the Disney of all experiences. From the time they hit the parking lot, I have music on, I have fresh coffee, I have cookies, I have treats. Each room is decorated. You can go to my website and see it like it's a living room. It's got a big screen TV in there with recliners. They are going to want for nothing. They are going to be comfortable. And the reason is because when we make decisions in environments that create some anxiety for us, we do better choosing if we're comfortable. So all of us have been to doctors and all of us have climbed up on stools or tables that are too high for us to comfortably get on crinkly white paper, right? That doesn't make anybody comfortable. And so in this environment, I want people listening, paying attention, working hard, thinking about what it's worth. So that when we get down to that decision point, I can say, so I told you in the beginning I was going to honor your choice. What I need to know from you is what choice will you make today? What will your tomorrow look like? And that's really kind of the end of it. So let me throw in another character that's present probably in a lot of your conversations. This is what I call the brother-in-law.
Yeah.
Okay. So how many times have you been on the phone or on email and somebody says, well, my brother-in-law got this in a case where they had the exact same injuries? How do you respond to that? Well, while you're thinking about it, I'll tell you what I said. I said, man, It's amazing, the same injuries and the same amount of money that you're asking for. But I said, look, I'll take all the help that I can get. Why don't we do this? Get your brother-in-law on the phone and let me speak with them about the value they got. Oh, why? I don't think he wants to do that. Well, I said, well, we really can't use what your brother-in-law got unless I understand fully the basis of how he got that amount.
Everybody's writing this down because everybody hears that.
Oh, yes.
Brother-in-law, uncle, cousin, sister got this much.
Right.
Okay, well, who was their attorney? Because I'm gonna want to speak to them to see how they got that much money for that kind of injury. Well, I don't think they really want to talk about that. I've used that before. Always play that card because it's the only way to shut it down.
I've never had a brother-in-law show up. Okay. The other one is the significant other, wife, husband, spouse. Look, I got 4 daughters. The only boy with 3 sisters. I love the female perspective. Okay. In most of the cases that I mediate, probably 60 to 75% of them are injured males. And oftentimes they'll bring their wife. And this is the dynamic. Okay. So I'm going to let Patrick be the wife. Okay. Now I'm going to let Patrick be the male. So lawyer starts talking about it. We get down to kind of the final number. And Patrick says, well, what do you think, babe? And he looks to me as the wife.
And that I don't know whether it's ubiquitous, but it's South Louisiana for sure.
Yeah.
My dad did all the heavy lifting. He did construction like his. But anytime it came to financial situations, that was my mom's strict purview. It'd be like, sweetie, what do you think?
So somebody's got to help me answer this one, okay? We got a lot of ladies on this group. And what do you think the wife says when she's not pleased with the amount of money that Patrick wants to accept because he's ready to be done with this? What does the wife say? Come on, that's an easy one. This is what the wife says. Well, I think they're screwing you, but it's your case. You do what you want. Let's walk away. That's a good one. Let's walk away. Either one of those is what I hear all the time. And so I turn to the wife and I say, look, I hear you, man. I mean, if you want to walk away, that's fine. Now, before you walk away, let me ask you and Patrick this. Is walking away from $75,000 in your pocket in 30 days better than $400 next week and maybe the next week and maybe the next week after that? And if it is, if that's working for you, you shouldn't settle your case. Nobody likes staying in workers' comp. And so what usually the wife says at that point is, well, that's ridiculous and all. I mean, we can't live on $400 a week and all. I mean, no, we don't want to stay in this. I said, so you really have a decision to make. You have a decision to accept $75,000, which you're not pleased about. But the real question is, are you less pleased about $75,000 in 30 days, or do you want to stay in $400 a week? Now, it doesn't always settle, but that's a tough question. And really what the wife is wrestling with is protection of Patrick, because she feels like her husband, her significant other, has worked so hard in his life that certainly all he's been through is worth more than $75,000. And she may voice that. And what do you say to that? Absolutely, Patrick's worth more than that.
But
there's no price tag for what Patrick's worth or what he's been through. But wife, remember, when we started this process, there are 2 responsibilities that an employer has. And they never can come faster than a week at a time or until the medical's approved. Now, I wish it were differently, but I don't write the laws, and that is what the law says. And that's my responsibility, is to give you as much information, just like a doctor would, for you to make the best decision. So your decision today feels like, as unfair as it feels, is it better for you and Patrick to take 75? Or is it better to give that back? Because remember what I told you in the beginning, they will spend everything they offer you today. The real question is how they spend it. And this is your chance to decide how they spend it. So do you want $400 a week for some undetermined period of time? Or do you want $75,000? And again, it doesn't always settle, but we call that framing. You have to help people frame. Here's the other one. You hear all the time. I know y'all hear this one. That's not enough.
What is enough?
What? No. Not what is enough. What's the question you want to ask them? Compared to what? The only way to make an assessment of whether something is enough or not is to have some idea of another value that you feel like is enough. There you go. Compared to what, Kayla? And when you ask them that, they will usually answer like this. Well, that's not enough for us to get our life back. That's not enough for us to put our daughter, who's a freshman at LSU, through her next year of school. Now, we had this planned out. Our life was going to go like this. That's not enough to do these things. To which I say, you're right. It's not enough. But that's not really what we're here today to decide. We're here today to decide whether $400 next week and the following week is enough compared to $75,000 in 30 days. I can't make that decision. Y'all have to. But make sure when you get ready to leave that you know that next week you'll get $400. See, that's a different way of framing it. I don't argue with them. I don't say, well, sure, it's enough. Sure, it's representative of 2.5 years with a $10 offset. I never get into the weeds with them on that. I get into that value that makes a difference to them. Now, we may have arrived at it by going through that process, but that's not what matters to people whose lives have been affected by this.
Yeah, we all know that you don't get pain and suffering in workers' comp. The attorneys know.
Some, fewer and fewer now because of
Yes.
the advertising piece.
The adjusters, but the claimants, they don't know that. They want their pain and suffering. If you cannot give them money to represent their pain and suffering, give them an opportunity to voice it. That someone is hearing it has value, because if you get caught up in the system where, you have a communication with the adjuster one day, communication with the adjuster the next day, nurse case manager, no one is hearing that no one is hearing that person's venting and that frustrations. And look, I know I hear it all the time with unrepresented, and it's not nearly what you have to go through, but sometimes letting them vent is cathartic. And it's a way to make up for what they're not getting in the pain and suffering arena. You can call a random plaintiff's attorney that you think will answer the phone call and go, what is the most common complaint you hear from your employee, from your claimants? Every single one. Well, I was a valued employee yesterday, and then I had an accident, and now they don't care about me. They just want someone to acknowledge that they're suffering. Ma'am, I understand. I understand. I can appreciate that. But the way the system works is like this. We're going to cut you a check next week, and the week after, and the week after. But if you want to get out of that system, if you want to take control of your life, if you want to give yourself back the power, then we need to talk about settlement. And sometimes, and you've said it yourself, and I know I've experienced it, mediation 9 times out of 10 is so that Alan can speak to the claimant. Okay, I can speak to the attorney all day. We can chat all day. We probably have 2 or 3 claims together. Hey man, what's up? Hey, look, dude, you want to settle this? Yeah, let's settle. What do you want to start at? I get from some attorneys, Patrick, my client is willing to settle, and would like $250,000. Sincerely, name of attorney. That's it, just $250,000. I know at that point, 1, they probably don't know how to value a case, or 2, they don't know how to value a case.
Yeah.
So one of the things that Alan had mentioned, I don't know if you caught that, every single initial demand that you're going to receive is absurd. I hear this once a month. Patrick, how can they think their case is worth $250,000? It's not. They don't. But they have to start somewhere. Okay, they are gonna work towards their number. That's why when recently I had someone ask me, why did you start so low? That's going to upset them. No, because I have to go just as far to what I think the value is. So I've got to start with absurd and let them know, look, I know your number's crazy. You know, my number's crazy. Then we're going to move towards the middle. But sometimes, especially when you're dealing with unrepresented plaintiffs, you can, like Alan said, you can throw acronyms at them. You can throw 3-letter, but let them vent a little bit. Okay. Get it off of their chest and then put it in that time game. Look, your claim in workers' comp every day is actually worth less. Okay. Ma'am, I can get into detail with you. I can discuss with you the law, but there are certain benefits that are paid that are time limited. So every day that we pay you, your claim becomes worth 1 less week. So the longer we sit around, your claim can actually lose value. Okay, while it may make you better, your claim is worth the most it's going to be at this time, at this exact moment. Next week, it's going to be $400 less. The court can't make up that gap. So that's one of those things that you have to form that connection with them. I know you don't have time. I know it's frustrating. I know people scream. I know people yell. I know people are rude. I know they are mean, but it's the best way to get to a settlement that makes your team leader happy, makes you happy, and makes the insured happy. Because the insured, they don't want to pay a dime. The employer may think, the employee may go, oh, they were mean to me after I had my accident. And I'm thinking to myself, yeah, that's kind of what they said. But form that connection. So I've seen him just, so what kind of work did you do? Oh, well, I know someone, 15-minute conversation in there talking about how they formed a relationship, and his dad did construction, and then I keep going back to that one with Remy because it was so enlightening, and make that connection. And that person had to vent, and thankfully he was very pleased with his attorney. But Remy, God love Remy, just couldn't get through to his client what the case was worth, what we owed. And it took Alan to basically say the same thing, but in a different manner. And so that's I don't necessarily know that mediation is necessary in every case, but there are skills that you can take. And like you said, it's forming that connection.
You ought to read the tea leaves, though. If you get somebody who's got a $250 demand and you make a $5,000 demand and they go up, you don't spend any more money in that case.
I've had that.
You said that case for mediation because any money you spend, you're wasting at that point.
I had a case recently, no one on here. Plaintiff's attorney goes, Patrick, my client is willing to settle for $24,500 because they don't want to hit 25 because of MSA. And I said, okay, we'll start off with $1,500. She goes, my client will take $33,000. I said, okay, you don't know how this works, and settlement negotiations are over.
Going the wrong way.
I told her, I said, we're done. Okay, Patrick, my client will take $23,000. Sometimes you just have to be able to go, okay, we're done. I mean, look, if you have to pay indemnity on this claim next week, you're still employed. But that attorney, because they wanted to be smart, may have just cost themselves 20% of $23,000. Okay. They have money in that game. So don't be afraid to just, okay, well, we're done. Client, I know my client, they're not going to give me any more money. Okay. Sometimes the game is not to settle. The game is to settle favorably to make your client's happy. Sometimes that requires you're done.
Well, it's a couple of steps. I mean,
Yeah.
you're posturing for the next discussion that can have some value versus responding to an offer that you up.
We've had a couple who've walked away, just too far apart, took time. Sometimes it was just about money. Sometimes they had to sweat. Sometimes I had to sweat. Sometimes we had MSA issues, what have you. But sometimes it just, okay, look, we're not accomplishing something. We're not getting anywhere. Don't be afraid to do that. Don't be afraid to let them complain to you. Be, I don't want to say be
Be firm.
be firm.
Yeah.
Be firm and say, look, understand this. It is your life, but for us, it's business.
Financial.
It's financial. My client is only looking at this financially. You're one employee, but my client has 100,000 other employees they have to protect. Okay. And so you always have to build that connection. Okay. I just wanted to make sure someone's going, Patrick, shut up. But anything else you want to offer, especially what's unrepresented, that's what they're going to be working with, those unrepresented claimants.
It is a tremendous challenge. When we had COVID, we continued to do mediations, and trying to explain to somebody, even with a visual, the mechanics of a workers' comp case and get a feel for really what their hope is in terms of this process is very difficult. I can only imagine, in fact, when y'all get really bored, which may take a very long time, try explaining to a colleague in your office without looking at them in written form how an MSA works. It's virtually impossible. I mean, we can talk about it, but if you don't have an understanding of Medicare's rules and how an MSA works, then you just, I don't know how you do that.
No.
I mean, it's just impossible.
Yeah, if you start getting into a discussion with the claimant about SEBs or TTD, you've lost them. Because they are going to think you are trying to be sneaky. Oh, he's trying to use words I don't understand. Ma'am, well, there's wage loss benefits, which is when you can't work. And then there's another type of benefit for when you can work, but you just can't make as much money. Okay, I can give you the names, but we're just going to confuse you. Those are the two types. Always bring it down to something that they can understand. I've noticed that when you start saying, when I first started, I would say TTD, SEBs, MMI, they sounded smart. They sounded, wow, he knows, I'm going to impress them into taking pennies on the dollar. But it was counterproductive because they thought I was trying to be all lawyerly and trying to sneak something around. No. What's an MSA? Well, ma'am, an MSA is because Medicare is built to protect all Americans. Medicare wants to make sure they're not paying for something that they don't have to pay. And if your employer should be paying for some of these medical benefits, Medicare does not want to. So Medicare will let you settle your claim, but the medicals that they would have provided for you now have to be set aside so that Medicare is protected. And there is no messing around with Medicare. So just get out of the habit of trying to use acronyms, fancy words, because they don't care. And for many people, it will intimidate them. That works for attorneys. When you're speaking to an attorney, you can use MMI, SEBs, TTD, PTD, what have you, because then you sound more sophisticated. But when dealing with employees, again, let them know that you understand. Let them vent. Okay, let them get it off the chest. Okay, don't force them. Okay, they're not ones. Some are. Some you have to just. That's it. We're done. But most people, let them walk away. Try and settle within a day or two.
Yeah.
Once you start. Explain why.
Ask twice as many questions as you offer responses to, and don't put any money in that discussion until you're satisfied that they have some appreciation that irrespective of what they want is not representative of what's owed. And until you do, you're spending money that you're not going to get value for.
Yeah.
The only other piece that I would throw in there is if Patrick and I are lawyers going back and forth, and he's representing the injured worker, and I call him and I say, hey, look, we're not gonna pay $250, but we'll pay 25. How do you think that discussion goes between Patrick and his client? Do you think Patrick takes the time to get his client in there to schedule an appointment, to sit down and say, look, they did this? That's how it used to be. It doesn't happen like that anymore. I'm just gonna tell you. What happens is Patrick outs out an email to client and says they offered 25. I think we should respond at 235. Client has no idea whether these numbers are coming or going. And that's why in mediation, I don't ever ignore the plaintiff's lawyer, but I don't want the plaintiff's lawyer being the one who explains this process, because they think like lawyers. They don't think like people who are in a bind.
Yeah.
That's the difference.
Yeah, it's, ma'am, we owe medicals, okay, only that are related. So we don't owe you your other stuff, okay, only related. And we're gonna pay the doctor. We're not gonna pay you. And then there's money, those checks that you're getting, that's for the money we owe you because you're not working right now. And so let's talk about your medicals and what the doctors are saying you will probably need. And let's talk about how it's going to affect your ability to work and how long before you can get back into the workforce. Okay, it sounds like you may not be able to do what you did before. Okay, and so let's talk about some other things you can do, how it will affect your income that may be affected. Okay, don't bring numbers in. Once you start putting a number in, they're going to think of their own number way out here. Because if you go, well, yeah, blah, 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 and so, $12,000. Look, I can do math that a person can have a 2-level fusion on the table, and I can show you math why it's a $12,000 case. Okay. I can also show you why that's a $120,000 case. But once you set the number, they are going to pick a number way outside. So I always want them to give me a number first.
Absolutely.
Ma'am, explain to them, here's what we're going to settle. We want to look at medicals. We want to look at, wage loss. We want to look at all this. Do you have a number in mind?
Let's say that number is 200,000. Let's say the math over the remaining SEB plus medical is 200,000. And Patrick says, we ain't paying 200,000, we're gonna try to get it for 75. It's like, okay, that's fine. So we go back and they offer 5. They said, that's ridiculous. We go through all of that. And the plaintiff's lawyer says, what's wrong with the 200,000? I mean, it makes sense to me. I said, that's a perfectly good number. And then I'll ask the claimant, now, how old are you? They'll say, well, I'm 54. I said, that's good. I said, at age 64, they will have paid $200,000 to doctors and to you a week at a time, and only when medical is approved. So the 200,000 is a 10-year number. Do you want to wait till you're 64 to collect that a week at a time? Of course, nobody wants to do that. So I want to be respectful of our time. We're finished at 1?
Yeah, 1:10.
Yeah, well, so I'll say these 2 things and all. There are a lot of tools that y'all utilize every day. And Patrick and I have talked about this. And most of those tools in managing a workers' comp case or mitigation or damage control, because you got to close the case to be done with it. Mediation in the appropriate form is the only tool who will give you about a 90% chance of closing the case. And as Patrick said, you can't mediate every case, but man, when one of those triggers come up or one of those flags go up, it's a low cost investment. It doesn't cost anywhere near what an SMO costs you. And what does an SMO do for you? It just gives you a contrary opinion, hopefully, because if they agree with the treating physician, then you're in a real big bind. And the second thing is this, there is an open invitation for any of y'all to come to our mediation facility in Baton Rouge. We call it Clarence Point. That is Latin for the point of seeing clearly. And I promise you, we will feed you, we will dine you, we have a catered lunch, and you will see why
and
that
warm chocolate chip cookie.
Yeah, you'll see why that environment works in terms of that. Now, I mediate cases. I've been in Shreveport all week mediating cases outside my office. So I go all over the state along with our other mediators. But Patrick's been there along with all of his partners, and they understand if we can get people there, then it's a really good environment to try to close the case.
And another thing, just to mention, because we had talked about this before, a lot of you, and I know there's not the broad mix that I had kind of hoped for because I wanted to make this a pitch. Most of you have old tail claims. Tail claims are miserable because you don't sometimes have time to look at medical records going back to 2012. Okay, what do I do with this? I'm just going to keep paying. It's easier. Well, yeah, you got to get rid of those claims. So one of the things that you had done for a while and still advertise is basically tail claim cleaning. Is sitting down, looking at some of these tail claims and mediating. Like another client that we do work for, very large, the largest, I'm not sure we can mention names, has settlement conferences twice a year. They just decide they're going to settle as many claims as they can in a year or at that time period. But if you have a backlog of tail claims that you inherited, or if you have a lot of claims that were shifted from another carrier, mediation can be a good way of going, look, I'll just say, attorney, I'm going to send you some files. I need you to look at them, evaluate them, help us set reserves, then get Prism on the phone and let's see if we can mediate 2 and 3 claims at a time. I've seen Alan mediate at Claris Point like 4 and 5 claims at a time.
We do like a Dr. Pepper day. We
Yeah.
start at 8, 10:30, 2:30, and 4.
And they will use that to close those old tail claims or the bulk transfer claims. And it's fast. It's faster for you because you're not just, well, I don't know what to do with the 2012 claim. I guess I just keep paying forever until, you know, someone like Michael goes, hey, why haven't you gotten rid of this file yet? It's an option. Maybe not doesn't work in every situation, but it's an option. I know I talked too much.
No. So give them my contact information.
Yeah.
If they need to contact me, I'm gonna give you one example. Case this week and all, 68 weeks left on the 520-week timeline. It paid $234,000 in medical. So right under 500,000, it's getting ready to roll into excess. And guess what the employer wants to settle the case for? 68 weeks. Virtually impossible with somebody who's 72 years old and been in this thing almost 10 years. But we get a very favorable number. And the way that we get that number is this. The only way for it to extend past 520 weeks is if they can prove by the highest burden of proof that their client is incapable of any form of work, part-time, self-employment, anywhere at any time. That's a high bar. There's some people like that. But almost everybody confuses Social Security disability standard with permanent and total in the state. And I explained to them they're very different standards, and we go on through that and all. But that person has been entrenched in this case so long, they're convinced they cannot work. And usually at some point, they say, what kind of job can they find me? And this is one of the things that I do. I hand the injured worker a pad with a pen, and I say, can you make a mark on that paper? And they do this. I said, you're not permanent total in this state, because the people you see at some retail outlets with markers that go through receipts, they are getting paid for that. Which immediately they say, I don't want that job. I said, that's not the standard. Yeah, the standard is whether it's available. So I want to thank y'all for your attention. I want to thank Patrick for inviting me. I think mediation is a wonderful opportunity, and this firm embraces it. They understand it because it brings value to their.
Yeah, and it's not just an advertisement for, hey, we like to mediate. You're going to get that same sort of mediation recommendation from anybody. But it's just you're given a job. Hey, go mediate these comp claims when you've been handling comp claims for a couple of weeks, months, or go settle them. It is a science. I mean, not a science. It is an art. How I thought the game was done when I first started to what I know now is night and day. So someone can give me a claim and I can look at it. I can look at the attorney. I can look at the doctors, and I'm going to go, yeah, $75,000. I've reached the point, and you can ask me, can you explain that? I'm like, no.
Yeah.
That's what it's going to take. And look, no attorney at any firm better. just call and go, hey, look, I got this, I got, this court, these doctors, these injuries, here's what we're looking at. What do you think? I may not be able, or any attorney may not be able to give you down to the penny, but we can get you within 10, 15, $20,000. That at least help you set reserves and see if, can I even get that much money out of the insured since we're now dealing with their money. If you get stuck, call an attorney you're comfortable with because you don't have enough time to spin your wheels. Okay, for something that you may have just started in terms of negotiating, call them. Okay, just make sure when you call and you speak to Michelle that Michelle's also not the plaintiff's attorney.